Good morning, ladies and gentlemen. The unsettling environment that we find ourselves in today, brought about by the pandemic, serves as a stark reminder of just how unpredictable life can really be. One of the things that we do know for certain, however, is that we will all eventually die. It is just a question of when. The one thing that we can control in this entire process is the extent to which we actually plan to protect and secure our dependents' financial future when we no longer can. Welcome to our webinar, where we will be discussing the estate planning considerations and tools to protect and secure your dependents' future. We invite you to engage with us throughout this webinar. In fact, we would like it to be more of a conversation, so we really invite you to make use of the chat function that is available on the right-hand side of your screen. Please use it to post questions and to post comments on anything that we discuss throughout the webinar. It gives me great pleasure this morning to introduce and to welcome you to my fellow fiduciary specialists who will be joining us during this webinar. So on the line we have Ilana Oosthuizen, who is based in our central region.
Good morning, ladies and gentlemen.
Ilana is joined by Devs Moodley in our central region.
Good morning, everyone.
And in our KZN region, we have Priscilla Reddy.
Thank you, Tracy. Good morning, ladies and gentlemen.
And in our coastal region, we have Hannelie Lagrange.
Good morning, everyone.
And last but by no means least, the thorn amongst the roses, we have David Jordan, who is based in the coastal region.
Good morning, everyone.
So really the format of the webinar today is I will shortly be handing over to Ilana Oosthuizen, who will be taking us through some slides, just really to get the thought process going in terms of those estate planning considerations and tools that we can use to protect and secure our dependents' financial future. So I'll be handing over shortly to Ilana Oosthuizen. Once Ilana's been through her presentation, we're then going to really enter into a conversation type part of this session where we're going to be addressing your questions. So once again, please, we invite you to post those questions to the chat function, and we'll then be engaging, and as I say, we'll be answering the questions as they're posed. You'll also receive an email after this webinar, and in that email there will be a link to the recording of this webinar. We really invite you to share that link with anybody that you believe may benefit from the content that we are covering this morning. And also it will provide you with an opportunity to revisit the webinar if there is something that really has stood out for you and you'd like to relook at it. So without any further ado, ladies and gentlemen, we're now going to move over to the presentation part of the webinar, and I'm now going to hand over to Ilana, who will be taking us through the estate planning considerations and tools to protect and secure your dependents' future. Over to you, Ilana.
Thank you, Tracy. Ladies and gentlemen, I'm going to start my presentation by first recapping some of the basic estate principles and explain some of the general estate and tax planning considerations. Then we'll look at some considerations and tools to assist in protecting and securing your dependents' future. And then I'm going to conclude by bringing it all together and highlighting important points to take out of this presentation and provide guidance in terms of the way forward. So let's start with the basic principles. So what do we mean by an estate? An estate is defined by the Oxford Dictionary as all the money and property owned by a particular person, especially at death. However, as one accumulates money and property during one's lifetime, and there are other life events other than death, for instance, marriage, the birth of a child, divorce, etc., an estate is actually a living thing. Accordingly, one should plan one's estate for both during and after one's life. So what are the general estate and tax planning considerations to look at? Firstly, continuity looks at the extent to which material events such as liquidation or death can disrupt the continued management or access to your assets. Orderly distribution after death considers the estate consequences and formalities such as possible freezing of assets, as well as related costs required to wind up your estate. Protection for dependents, which we will be focusing on today, considers the financial protection for your minors or those with disabilities, or the intergenerational wealth transfer. Protecting assets from seizure, the ownership structure you are in will affect the legal ownership, and each vehicle will provide varying combinations of protection for, say, government or creditor risk. Tax costs and administration implications consider the applicable tax rates and associated tax risks, as well as the administration consequences that stem from how your assets are owned. And lastly, flexibility of your estate. At the outset, ensure that your assets are owned in a way that allows for changes in your circumstances, regulations, and best practice over time. Bringing this all together, what does estate planning involve? It involves the structuring of your wealth optimally for both during and after your lifetime, planning for all life events, understanding the financial impact of death, i.e. the cost that will apply, and making provision for these costs, understanding the tax consequences of the structures and products used both during and after your lifetime, and then having a valid up-to-date will to ensure the right people benefit from your wealth. So now you're asking, why is estate planning important? It gives you peace of mind that the way your wealth is structured allows for changes over time, and that it provides protection against risk, such as creditor risk. Having peace of mind that your wealth will devolve as you intended if you pass away. Protect your beneficiaries and children and any other vulnerable members of your family, and ensure cost and time efficiency by avoiding unnecessary delays in payouts and minimizing costs such as taxes. Generational wealth planning has given rise to a more intense focus on the tools available to ensure that wealth is safely transferred to the intended dependents, and that those dependents are correctly equipped to receive and protect their inheritance. Hence, today, we will have a closer look at some of the useful estate planning considerations and tools to protect and secure your dependents' future and ensure the efficient distribution of wealth to the next generation. We will be focusing on having a will, the use of trusts, beneficiary nominations on life policies, death benefits, and living annuities. So let's start with having a valid up-to-date will. As you know, life has a way of happening when we least expect it, and the unprecedented times, as Tracy mentioned, that we find ourselves in today serve as a reminder of how quickly things can change, and sadly, how quickly life can be taken away. This uncertainty necessitates proper estate planning to ensure that when the time comes, you are not anxious about whether sufficient provision has been made for your loved ones after you are gone. Arguably, the most important document we all need to have is a will, and that it reflects our current wishes, as this will become our voice when we no longer have one. Ironically, however, this is also often the most neglected document. A will has a significant impact on how your family or those dearest to and dependent on you will live after you die. A lifetime of building and preserving your wealth can be undone by not having a will. The task of drafting an appropriate, viable, and valid will should thus be entrusted to the care of a seasoned advisor, because, unlike most other errors, this is one that cannot be remedied. It's also important that you review your will from time to time, and a change in your personal and financial circumstances should automatically trigger a review. Examples of these changes in circumstances could be a relationship milestone, for instance, a new long-term relationship, the birth of a child, substantial addition or sale of your assets, death or insolvency of a beneficiary, or a significant change in your financial situation or assets. Other things like tax legislation or decisions made by courts could also impact on your estate planning and your will. My question to you today is, when last did you review your will? The second effective tool we will look at is a trust. A trust can be used to ensure the safe transfer of wealth to your dependents and that they derive the most value from your estate and the assets you've worked hard to acquire. It is of utmost importance that trusts are set up with the correct intention and to achieve a specific purpose or set of purposes. So why should you consider setting up a trust in your estate plan? One of the primary reasons for setting up a trust is to protect your estate and assets. This is especially beneficial in the event of liquidation, sequestration, or divorce. The great advantage of a trust is that it allows you to enjoy the use and the fruits of the asset while not having ownership of that asset. A trust may also be set up to protect and provide for dependents or relatives who may not be able to look after themselves or take care of their financial affairs. A trust is also an effective succession tool. A trust puts your assets under the control of trustees who can act in your place for your beneficiaries once you've passed away. This allows for financial security for your loved ones in the event of your death or even absence or incapacity because of illness. Once a trust has been validly set up, the trust can continue indefinitely, provided sufficient provision is made for the continuation of trustees to administer and control the trust. Accordingly, the death of a beneficiary does not impact the existence of the trust or the ability of the trust to continue to provide for the remaining beneficiaries. In considering the use of a trust, it's also important to remember that a holistic decision should be taken and that using a trust as a vehicle for estate planning can be a complex exercise, and proper advice should be obtained which considers your current and future needs and financial capabilities. Your trust should also be revisited every time there is a significant change in your circumstances. This includes revisiting the provisions of your trust to determine whether they are still appropriate in the light of your overall estate plan. As we discussed, setting up a trust can yield benefits, but there are key challenges to consider when it comes to trusts. If you place your assets in a trust, it's argued that there's a loss of ownership or control over these assets, as trustees will now be responsible for how those assets are used and also distributed. Many clients are not comfortable with relinquishing control over their assets. There are also costs involved in establishing and managing a trust, and these costs can escalate if you don't set up the right trust for the right reasons. Costs should thus be weighed up against the benefits to ensure that it makes financial and practical sense. Then the taxation of a trust should be considered. A trust should not primarily be used to mitigate paying estate costs and taxes, and overall tax efficiency is very important. And then lastly, it's noteworthy that the establishment of a trust isn't in every individual's best interest. And this is why it's essential to speak to an experienced advisor, as they can help you objectively assess whose best interest matters most when you're planning your estate and if you should set up a trust. There are several trust options available to South Africans who want to secure their dependents' financial future, like a testamentary trust that can be set up on your death, and that would serve to protect any interest of minors or dependents who may not be able to look after their own finances at the time of you passing away. Secondly, an inter vivos trust can be created while you're alive, and you can provide protection for your family's wealth over generations to come. There are various factors to consider when deciding if a testamentary or an inter vivos trust would be the best option for you, some relating to family issues and others to monetary and tax considerations. And then we need to look at and consider a special trust. Special trust can be an effective tool for safe custody of assets intended for minor children or beneficiaries with special needs. There are basically two types of special trusts. The first one is an inter vivos or a testamentary trust created for people with special needs. For example, individuals with serious mental or physical disability and who are unable to provide for themselves financially. Setting up a special trust for these beneficiaries can ensure the safe custody of assets while at the same time enjoying special tax dispensation. They can provide enormous peace of mind for parents of special needs children who are concerned that their children will be taken advantage of financially after their death. The second type of trust is a testamentary trust for minor children, a trust used to house assets bequeathed to minor children or beneficiaries in terms of one's will. For parents of minor children, setting up a testamentary trust to house assets bequeathed to them until they are old enough to manage their own money is an excellent way of protecting the assets while at the same time enjoying some tax benefits. However, the correct wording of the trust deed, i.e. will, is essential to ensure that the trust founder's objectives are honored and that his beneficiaries' assets are protected. Now, the third tool worth discussing is beneficiary nominations on life policies. Life policies, insurance policies can be used to make financial provision for your spouse or beneficiaries and create liquidity in your estate. However, as with other estate planning tools, it's essential to correctly structure your policy so that it serves its intended purpose. The liquidity of your estate may be adversely affected by nominating a dependent as beneficiary of a life policy instead of your estate. When you take out a life policy, you will be asked to nominate a beneficiary. On your death, the proceeds of the policy are paid to the beneficiaries as nominated by you on the nomination form. Your will cannot deal with the distribution of the policy proceeds unless the policy proceeds are paid to your estate. If no beneficiaries have been nominated, the proceeds of the policy will be paid to your deceased estate upon your death. A common misconception is that in nominating a beneficiary for the proceeds of the life policy, the proceeds are removed from your deceased estate and are therefore not subject to estate duty. This is not so. It will be regarded as deemed property in your estate, and the value of the policy could be taken into account when calculating estate duty. The effect of the nomination is merely that the proceeds are paid directly to the beneficiary and therefore result in a saving of executive fees payable on the proceeds. Reviewing beneficiary nominations on policies are often neglected. It's important that you review your policy nominations on a regular basis. The correct use of beneficiary nominations on policies ensures for a truly robust estate plan. When considering beneficiary nominations, you should look at the type of policy that you have, the purpose for which you took out the policy, for instance, to create liquidity in your estate, to settle a specific debt, or pay a maintenance claim. You should also consider the effect of the nomination on the administration of the deceased estate and whether it fits into your holistic estate plan. In calculating the appropriate level of life cover required, it's important to take into account factors such as how much debt would need to be covered in the estate, your estate duties and taxes, and the extent to which you would need to provide for your dependents and loved ones. It's also important to discuss the nomination of minor beneficiaries, as it's common for parents to nominate their children, often minors, as beneficiaries on policies. It's important to consider the implications before nominating a minor on a policy. The proceeds of a policy will usually be paid to the minor's guardian. The problem with this is that the proceeds might never reach the minor for whom it was intended. It has been our experience that different insurers do deal with minor beneficiaries in different ways. Some insurers will pay into the bank account of the minor, others do pay to legal or natural guardians, and other insurers assist on paying into a trust for the benefit of the minor. This should be considered. Another problem would be where there is more than one guardian. In a culture as diverse as ours, it's possible for a minor to have more than one guardian at the time of death of the policyholder, and each guardian will be competent to act independently and without the consent of the other. And lastly, another problem is where the minor doesn't have a legal guardian. In such an instance, the proceeds will have to be paid to the guardian's fund until the minor reaches the age of majority, which is 18. The problem with the guardian's fund is that accessing the money can be quite cumbersome. Therefore, it's advised that you consider alternative options. One of these alternative options could be a testamentary trust. A testamentary trust is particularly useful when combined with life insurance. Within your will, you state that the testamentary trust is to be set up for the benefit of your children upon your passing. You can then decide on the age when each of your children will inherit their share of the proceeds. The proceeds will then be payable into the testamentary trust for the benefit of your minor children. Make sure that you have enough life insurance to take care of the income needs of your children, settle any debts you might have, and cover the cost of administering the testamentary trust. The second option to consider is an inter vivos trust. Nominating your existing inter vivos trust as a beneficiary on a life policy can be beneficial. There could be less delay in payouts of proceeds, and in most instances, immediate funds could be available to children for maintenance. However, note that because the proceeds are not paid to the estate, no executive fees would be payable. Also, make sure that you have sufficient cover to take care of the income needs of your children and to cover the administration costs of the trust. Now, let's have a look at the beneficiary nominations on death benefits. Retirement funds are governed by the Pension Fund Act and specific fund rules. Every retirement fund is managed by a board of trustees, and they are responsible for the allocation, distribution, and payment of lump sum benefits payable on the death of a member of a pension fund, provident fund, pension and provident preservation fund, and retirement annuity fund in terms of Section 37C of the Pension Fund Act. These benefits are colloquially known as death benefits. Section 37C limits the testamentary freedom of a member, and a member is not able to dispose of his death benefit as he wishes, i.e. he cannot bequeath the benefit to a specific person in his will, as he would normally with other assets in his estate. Even though the member usually completes a nomination form, such nomination is not binding on the trustees, as the benefit must be strictly distributed in accordance with Section 37C. It is argued that this limitation on testamentary freedom is justified if one considers the important socio-economic purpose underpinning this section. The death benefits do not form part of assets in a deceased member's estate. Instead, Section 37C places a duty on the trustees of the fund to allocate and pay the benefit in a manner that it deems fair and equitable to dependents, and only in exceptional circumstances may the benefit be paid to the estate. This duty of the trustees requires that the trustees identify the dependents and nominees of the deceased member, and then by taking into account relevant factors, they need to effect an equitable distribution of the benefit amongst dependents and nominees, and select an appropriate mode of payment for the benefit. A major beneficiary has a choice to receive the total or a portion of the benefit allocated to them as a lump sum or as an annuity. Okay. Lastly, we're going to look at living annuities. Living annuities make excellent estate planning tools and can facilitate the smooth transference of invested capital to one's dependents. Unlike other retirement funds, owners of most living annuities have the freedom to nominate beneficiaries, including trusts, to the annuity, thus ensuring that the nominated beneficiary have immediate access to the funds in the event of death. It is not a requirement that your nominated beneficiary must be financially dependent on you. When no beneficiary has been nominated, proceeds of the living annuity will be paid into the deceased estate. Winding up a deceased estate can take months or even years, making living annuities an attractive estate planning tool, especially because it provides you beneficiaries with almost immediate options in respect of accessing the capital bequeathed to them. Depending on the institution and the product, beneficiaries will have the option to make a full withdrawal of the capital housed in a living annuity, although it's important for them to bear in mind that the capital will be taxed as per the retirement tax tables applicable to the deceased. If making a partial withdrawal, they could have the option of transferring the balance to a living annuity in their own name. Alternatively, beneficiaries can also choose to maintain the living annuity in its current form, with the option of adjusting the underlying investment and drawdown levels in accordance with their financial circumstances. Importantly, money invested in a living annuity does not form part of a deceased estate and therefore does not attract estate duty. In conclusion, there are 3 key points for you to take away from these slides. It's important to conduct regular reviews of your will, beneficiary nominations and ownership structures, especially if there have been changes in your circumstances or legislation. Careful consideration of the estate and tax planning considerations relevant to each individual's particular needs and circumstances are key. There is no one size fits all. We can assist with generational estate planning by ensuring that our clients have an appropriate legal structure and estate planning tools to ensure efficient distribution of wealth to the next generation. So, how can we help you protect and secure your dependents' future? We have a team of fiduciary specialists who work closely with your wealth manager or advisor, and together they can prepare an estate plan for you and assist you to utilize the correct tools and products to assist you with generational wealth planning and protecting your dependents. So in conclusion, yes, it's complex. However, we are here to help you. Ladies and gentlemen, thank you. I will now hand over to Tracy, who will facilitate the panel discussion. Over to you, Tracy.
Ilana, thank you. I think there was a lot of really useful information that you took us through in that presentation. I mean, I'm just busy digesting it all, and I think there were a couple of things that I think really stood out for me. I think, if you look at it from an estate planning perspective, I think the first thing that stood out to me is that estate planning is about planning for both during and after one's lifetime. I think we all have this perception that we only need to plan for the inevitable, but it is also important that we do plan for both during our lifetime as well. I think the other thing that really stood out for me in terms of estate planning, and I guess it's of particular importance if we look at this unsettling environment in which we find ourselves, and that's really around the fact that proper estate planning and ensuring that you have the right structures in place, etc., it can provide one with that much needed peace of mind, as you say, Ilana. I think if we look at it from the estate planning tools perspective, I mean, there's a couple of things there. I mean, as you say, Ilana, arguably the will is the most important estate planning tool that everybody needs to make sure they have in place. And as you say, it becomes our voice when we no longer have it. That's why it is such a critical tool to utilize. It's really interesting and pleasing to see that a trust remains an effective estate planning tool, and it ensures the effective transfer of wealth. Looking at the beneficiary nominations, that under the right circumstances, nominating a beneficiary, that's also a useful estate planning tool. I think if we look at the death benefits, and I think really what was interesting there is the whole testamentary freedom limitation that's imposed, and the fact that really it will be up to the trustees to allocate one's pension funds in a fair and equitable way. A living annuity, that is also an excellent estate planning tool. And I think you summed it up at the end, Ilana, when you said that really one needs to look at each person's particular circumstances in order to determine what is going to be the opportune structure for them, and there is no one size fits all. So Ilana, really thank you. Thank you. That was really, really informative. So thank you. Ladies and gentlemen, thank you for the questions that you are posing in the chat field. We encourage you to continue posing those questions. And really the next session now is going to really be to try and engage more with you and really try and bring this all a little bit more to life in terms of addressing the questions and answers, and really just having a discussion with the greater fiduciary specialist team. So I think perhaps the easiest way to do this is going to be to really look at each of those estate planning tools that Ilana took us through, and to look at the questions that are coming through on that, and we're also just going to discuss it amongst the fiduciary specialist team as well. So I think really if we start with that very important document, the valid, ensuring that one has a valid and up-to-date will. And David, I think, if I may start with you, I think what would be really useful for a lot of clients is if we could share with them some of the pitfalls that we come across when reviewing our clients' wills. David?
Thanks, Tracy. Yes, I mean, if sometimes I, get wills that I need to review, and I often see that those wills might have been drafted by somebody that's not au fait with either the legal requirements of a will or perhaps the standard clauses that are normally used. Now, the omission of certain standard clauses could have serious consequences. For example, the Revocation Clause. Now, the Revocation Clause essentially revokes all previous wills. It prevents previous wills having any legal effect. Now, if that's not done properly, the current will and the previous will have to be read together. And if there is a conflict between the two, that certainly will have serious consequences. Often I see that there is a disconnect between the cash bequests made and the liquidity position in the estate. If there's insufficient liquidity to service the cash bequests, the executor may have to sell certain assets to create the liquidity, and that could certainly be contrary to the testator's wishes. Another point that I find is that, most clients have wills which deal with both their South African and international assets. Now, generally speaking, these wills are legally valid, and normally you only need one will to deal with all your assets. There may, however, be instances, and that very much depends on the nature of the asset and the jurisdiction where the asset is in, that you would need separate wills. Now, this must be judged on a case-by-case basis, and proper advice needs to be sought for that. And then, speaking of assets in other jurisdictions, I sometimes see that people either ignore exchange control regulations, or they may have overlooked it. And often I find, in wills where the testator bequeaths his or her offshore assets to South African trust. Now, in terms of current exchange control regulations, a South African trust may not hold offshore assets. In cases like these, those assets will then have to be sold and repatriated. Yet again, not necessarily what the testator intended. So Tracy, there are many other pitfalls, but I think in essence, one should take proper advice when you draft a will. Back to you, Tracy.
Thanks, David, and that's really true. I mean, in particular, the pitfall that you highlight with bequeathing offshore assets to a local testamentary trust. I mean, a lot of people go to extreme lengths to start building up and diversifying their portfolios internationally with the intention that they want those funds to remain. So it is very important to make sure that in fact does happen. And as you point out, that it doesn't inadvertently revert back to South Africa, defeating that whole objective of getting that international exposure. Thank you, David. I guess one of the other things that has come up is, we live in the 21st century, and Devs, we often see, each family structure actually looks different in this kind of modern world in which we find ourselves, and we often come across the scenario where a client has a diverse or blended family, and I guess one could also argue that we could define it as a modern family, in as much as that, that family structure could comprise an ex-spouse, it could comprise children from prior relationships, and there could be remarriage, there could be a current spouse with current children from a current union. So, in that example, or in that scenario, Debs, what are the kind of things that a client would need to consider when drafting a will?
Thanks, Tracy. So one of the important considerations a client should have would relate to any maintenance obligations a client has towards his ex-spouse, towards any children he has from a previous relationship, a current marriage, a previous one. It's important to note that maintenance obligations do not simply come to an end on death. They continue. An ex-spouse, a current spouse, kids could all have a claim for maintenance against your estate over and above what you leave them in your will. So the ranking of these claims is essential, and it's very important. A suggested consideration for a client to have would be life cover. Life cover can be used to service the maintenance obligations that a client has. This, coupled with a structure like a testamentary trust, could prove very, very useful. Instead of a testamentary trust, a client could use an existing structure he has, like an IV trust. For example, and depending on the client's specific circumstances, a client could leave a life policy or have a life policy on his life, with the beneficiary being the testamentary trust created in terms of his will. The trustees of that trust can then use the funds of the policy to settle any maintenance obligations the client may have. In the circumstances where you have such a diverse and blended family, it's important to ensure that you cater for all your various obligations accordingly. It's also vital to consider the impact of those obligations on the liquidity of your estate. If there is insufficient cash available in your estate and you have not made sufficient provision for your obligations that you have, the executor may be forced to sell assets in order to get the cash to settle those obligations. Back to you, Tracy.
Thanks, Devs. Yeah, and I think it's also, I guess, important just mentioning as well, you know, that the more diverse the family structure, the more important it is to make sure that you have the will properly drafted, because there is a possibility of wills being challenged as well under those circumstances.
Yeah.
So, agreed. Thanks, Devs. And I think, Devs, if I may just, you know, whilst I've asked you something, I mean, something else that's just come up, and just for the audience out there as well, please, we really encourage you and invite you to post your comments, to post your questions, to please keep those coming. So one of the other things we often see is that clients would like to leave large cash legacies to beneficiaries. You know, so in the scenario where a client would like to leave a cash legacy of, say, I don't know, 5 million to each of his 4 children in his will, you know, what would you recommend the client considers, and what would be important to highlight to a client that is looking to leave those fairly large cash legacies to his children?
So Tracy, in this specific scenario, it's important to understand the reason behind why client wishes to leave such a cash bequest to his kids. It's important to understand the circumstances of each child. So their age, their specific needs, whether the client has catered for the expenses over the child's lifetime, and whether the child is dependent on the client to service such expenses. We would need to understand whether the child is financially astute and in a position to handle the funds, or whether a trust could be used. It's also important to consider the liquidity of the estate. We would need to look at whether the estate has sufficient cash to service the 20 million rand cash bequest or cash bequests to children, as well as to settle outstanding obligations, outstanding liabilities, estate costs, and other taxes. If there is insufficient cash in an estate that is available, again, your executor would need to look at selling assets to create the liquidity position to service all the expenses and the bequests. So the viability of a bequest needs to be looked at from a whole estate picture as opposed to in isolation. Back to you, Tracy.
Thanks, Devs. And I think that's really a good example of where the use of more than one tool also becomes really efficient from an estate and transfer of wealth perspective. So thanks, Devs. I think so really, I think those seem to be most of the questions from a wills perspective. I think if we move on now and just looking at the next estate planning tool, which is really the use of trusts. And as Ilana highlighted, trusts are still a very efficient estate planning tool to use for the transfer of wealth. But I guess, Haneli, if I can now shift down to the Cape and perhaps just ask you for your views, would it be recommended to establish an IV trust or a testamentary trust if a client owns the bulk of their assets in their personal capacity? And let's just say the beneficiaries are a spouse and minor children. Just your thoughts on that.
Thank you, Tracy. Yes, I think there's so many factors to consider really in that scenario when a client is considering whether to establish a trust during their lifetime, so in other words, an inter vivos trust, or then a trust in their will, testamentary trust as it's referred to. But this decision is really dependent on the circumstances of the client and specifically what is then the nature, the value, the jurisdiction of those assets. But definitely from a continuity point of view, it may be recommended for that client to actually establish an inter vivos trust, so a trust during his lifetime, and to actually fund that trust as well during his lifetime. In that instance, the client death would not have an impact on the assets held in the trust. Therefore, his beneficiaries could actually benefit from the trust assets immediately after his death. So in other words, they would really have that immediate access to those assets to cover their living expenses, for example, and there is no period that they would have to wait, no delay that's caused by the winding up of the estate of that client. So really important to keep in mind though, if we're talking about inter vivos trust and we want to ensure continuity in respect of those trust assets, we actually need to fund the trust during the lifetime or during your lifetime. So that client would actually have to effectively transfer his assets into that inter vivos trust during his lifetime, and that really is a consideration on its own, because the client needs to then weigh up for him and for his family, is the benefit of providing for his beneficiaries, providing that immediate access to assets, is that benefit, does that outweigh the actual cost of funding the trust? Because obviously it's important to take that into account as well in terms of initial funding costs, but also ongoing trust administration costs. And if the client is not comfortable with that, instead for the client to then consider the testamentary trust option. Back to you, Tracy.
Thanks, Haneli. And yes, I mean, I think you've hit the nail on the head. It is all around doing that cost to benefit analysis and determining whether or not the benefits outweigh the costs. So Priscilla, I'm going to turn to you now. So we're shifting now to KZN. Hopefully the weather's cleared up a little bit. There's not too much rain and wind on your side. But one of the major detractors that I come across when I talk to clients about setting up IV trusts in particular is, that using a trust, there's this perception that one loses control over one's assets. And I guess so the real question would be that if a client does set up a trust, would the client still be involved in the decision making once his assets are transferred to the trust?
Thanks, Tracy. That's often a huge challenge for most of our clients in terms of relinquishing control over the trust assets. However, it is important for a client to understand that they need to do so in order for the trust not to be regarded as an alter ego trust. However, they can seek some comfort in terms of they would be co-trustees, so they would still be involved in the decision making in terms of the management and administration of the trust assets. They also have further comfort in appointing succeeding trustees to themselves in the will. This would ensure that the trustee that they nominate would have the same objectives that they do, and this provision can be done in their will, provided these powers are granted to them in the trust deed. So in terms of a local trust, all of this can be done in a trust deed. When we're looking at on the international side, unfortunately, it's not recommended that the trustee, you be a co-trustee on that trust, because that international trust would then form part of the SA tax ambit. However, the client can draft a letter of wishes, and the trustees on that international trust will be guided by that letter of wishes, and the trustee, the client himself would be comfortable in that manner that the trustees would be looking at those letters of wishes. Back to you, Tracy.
Thanks, Priscilla. And I guess, you know, in fact, one of the being a major distractor or perceived distractor for a lot of people, this loss of control, I guess in essence, that's what you actually want to do. You want to be seen to be distancing yourself from those assets in order to really benefit from all the benefits that a trust can provide. Thank you, Priscilla. Hanneli, I'm going to go back to you now. And this is really, you know, I think, you know, I'm really just trying to get into the whole, you know, special trust kind of ambit, and should someone have, as an example, a Down syndrome child, how could that person provide for this child once he or she passes on? Once again, just making sure that one does plan and has the necessary plans in place to protect that particular child.
I think, Tracy, in that instance, I think that client could consider actually creating a special needs trust. And that trust, as Ilana mentioned in her presentation, that can either be during one's lifetime, so inter vivos, or in terms of your will, testamentary trust. And that would really provide for that child, that Down syndrome child, but also have make use of the benefits that actually go along with having a special needs trust, and that's really from a SA tax perspective, those benefits. So as Ilana mentioned in her presentation, a special needs trust can be created for individuals that have a severe mental or physical disability, and actually are unable to provide for themselves financially. So I think really in that instance, that would be the preferred way to go. Over to you, Tracy.
Okay, thanks, Hanneli. Priscilla, I'm now going to shift back to KZN, because, you know, one of the things that we do find is that clients establish trusts and they have them in place for many, many years. And let's just say, you know, somebody established a trust, say, I don't know, 20 years ago, and the trust deed has not been reviewed since the trust was established, or it hasn't been amended. Is this acceptable? I mean, is it acceptable to set up a trust and then effectively just to leave it for 20 years and never look at it again?
Yeah, so Tracy, it's a very good question. We often come across clients that have drafted trust deeds and haven't actually looked at the document. So the answer is no. You know, the trustee definitely needs to be amended to take changes in legislation into consideration, because this would be advantageous to the beneficiaries of the trust. Also, the trustee needs to take the current intentions of the settler into consideration. So it's advisable, you know, to update the trust deed when there are changes in legislation, when there is changes in the client's specific circumstances. Also, it's advisable to ensure that there's an independent trustee on the trust that would comply in terms of the master's directive. Back to you, Tracy.
Thanks, Priscilla. Thank you. Yeah, I mean, it is, as you say, I mean, it is really important that one does continuously review things that are put in place in order to ensure that they still stand up to current legislation, best practice, etc. So another question, I mean, that's coming up, Hanneli, is around why is it important to appoint an independent trustee on a trust? And I guess there is a lot of talk around, you know, the need for an independent trustee to be appointed.
Yeah, Tracy, for trust to really be effective, it must be formed and administered in such a way that it's clear that no one person is actually in sole control of the trust assets. So if a court should find that the donor was actually effectively controlling the trust, there's a real risk that the court will in that instance actually regard the trust assets as being the donor's personal assets. So what this could mean is really that those assets are then, for example, subject to attachment by creditors in the event of insolvency, taken into account in divorce proceedings, or then even included in the donor's estate for estate duty purposes at death. So taking this into account, and to ensure that this is not the case, the appointment of an independent trustee is really recommended. So that independent trustee should then be a professional person, so attorney or accountant, for example, and that person would really be responsible for ensuring that the trust functions properly, that the provisions of the trust deed are observed, and the conduct of other trustees can be scrutinized and really checked in that way. So appointing an independent trustee is really important for that aspect. So where you actually appoint, instead of an individual independent trustee, you appoint a corporate independent trustee, such as Nedbank Trust. That would actually provide you with continuity as well in the management of the trust. And there's no end in the management at the end of the lifetime of the individual, like the individual case, but there would actually be continuity. And that corporate would actually also ensure that all legislative and regulatory requirements regarding the proper governance of the trust are met. So for me, that's really why it's important to have that independent trustee appointed. Back to you, Tracy.
Thanks, Hanneli. I mean, I guess another important reason is also just around the fact that having an independent trustee, they're hopefully able to separate that emotional kind of aspect from a family dynamic perspective, which I think often we see where we have family members that are acting as trustees on a trust, but it's very difficult for them to separate the emotional family dynamics in fulfilling that role of trustee. So really, I think just one more question. In fact, I think what I am going to do, just cognizant of the time, once again, ladies and gentlemen, thank you for the questions. Please keep posting them. But just one, I think we can move on now, just looking at the beneficiary nominations on life policies. And Debs, I think let's bring you in here again, if we may. But where someone has a life policy, and once again, let's just say it's 10 million, and the beneficiaries of the policy are that person's children, what should the client take into consideration when finalizing the beneficiary nominations?
Thanks, Tracy. And this is a query we get often in our space. So firstly, it would be important to ascertain the age of the children involved. If the client has children that are minors, one would then need to take cognizance of the fact that the proceeds of the policy would be payable to the minor's child's appointed guardian. In this instance, client would need to understand that the use of the funds is at the discretion of the guardian. In the event that no guardian has been nominated for the minor child, the funds will be held in the guardian's fund, and this is never recommended. In this circumstance, it may be best for the client to amend his beneficiary nomination to a testamentary trust created for the benefit of the minor child. Or alternatively, if the client does have an existing structure like an inter-vivos trust, he could nominate as a beneficiary of the policy the inter-vivos trust. In the event that a client has children that are above the age of 18, client can choose whether to leave funds or portion of the policy to that to the major child who's financially mature. Alternatively, a client always has the option to leave funds to a structure such as a testamentary trust or to an existing IV trust for the benefit of his children until a stipulated age. Back to you, Tracy.
Yeah, and once again there, Devs, I mean, we're seeing the use of multiple estate planning tools coming to the fore. So the beneficiary nomination linked with the trust. So Priscilla, I mean, I think we all seem to get this, but in families as diverse as they are, we all, well, not, I shouldn't necessarily say all of us, but there are often those beneficiaries where I guess one could consider them to be, I don't know what the right word would be, but they could be considered prodigal or spendthrift type individuals. What would your recommendation be on beneficiary nominations for those types of individuals?
Well, thank you, Tracy. Yeah, you are correct. It is quite a common situation that presents us with clients, and I think in these circumstances it would be best for the client to utilize an existing inter vivos trust or a trust that's created in terms of their will, which would be your testamentary trust. So in that manner, the proceeds of the policy is protected and the trustees would then administer those proceeds for the benefit of the beneficiaries. So there would be that comfort in terms of the administration of those proceeds. Whether it be an inter vivos trust or testamentary trust, that would be, dependent on the client itself, dependent on the client's scenario, situation. So we'd have to have that kind of discussion with the client and best advise them in terms of which trust would be a better option for them to choose. But I would definitely say utilizing a trust structure to receive the policy proceeds. Back to you, Tracy.
Yeah. Thanks, Priscilla. Makes perfect sense. Just cognizant of the time, and once again, please, if there are any further questions, please make use of the chat function. Turning now to retirement funds and death benefits in terms of Section 37C of the Pension Fund Act. And David, shifting down to the Cape now, moving away from KZN down to Cape Town. What happens if the member of a retirement fund has minor children at his death or her death?
Tracy, yes. In the definition of legal dependents, a minor child is defined as such. And of course, a minor child would benefit from the retirement fund at the death of a member. Now, the trustees of the retirement fund will decide how to pay that benefit. And they can either pay the benefit directly to the guardian of the minor or primary caregiver, provided, of course, that that person is competent, or they would pay to a beneficiary fund, or they could pay to a trust which was nominated by the member during his lifetime. Now, this nomination may depend on the specific institution, whether it allows for that nomination other than individuals. Now, the main risk, of course, with the guardian, when payment is made to the guardian or the primary caregiver, is that there's no guarantee that the funds would be used solely for the benefit of the minor. If it is paid to a beneficiary fund, then at least you have the peace of mind that the funds are protected in a regulated tax-free vehicle and will be preserved for the benefit of the minor to ensure optimal education and benefit. Similarly with the trust, I mean, there that the trustees would look after those funds for the benefit of the minor, and of course those are the trustees that you have chosen. Back to you, Tracy.
Thanks, David. And ladies and gentlemen, I'm afraid to say, but we are now out of time. So we're going to have to leave it there with all the questions and that discussion. But to my colleagues, I mean, thank you. That was really interesting, and it was very interesting going through those different scenarios and the different questions. So thank you. So really, ladies and gentlemen, I mean, just bringing the webinar to conclusion. We trust that you found this session to be useful to you. If you would like to discuss anything that we've raised or discussed here today, if you would like to discuss that further, we invite you to please reach out to your relationship manager, to please discuss it with them. They will also call us in from a fiduciary specialist perspective, so we would be happy to engage with you on a one-on-one as well. Just as a reminder, you are going to receive an email with a link to this recorded webinar. Please do share it with other people that you believe will benefit from it. I think it's also important just to mention that your views are important to us. So please provide us with feedback in terms of this webinar, whether you found it was useful, if you've got any comments in terms of how we can improve our webinars going forward. Please reach out to us and do complete a survey which will be sent out, a very short survey that will go out via email as well. So lastly, and once again by no means least, just a big thank you to all of our clients for attending this webinar. A big thank you to my colleagues for participating in this webinar. And thank you all again, and go well and stay safe. Thank you.